Welcome to SQE1, and here we start chapter 4, and we focus on EU law and constitutional framework in United Kingdom. So, to start with, we need to understand what was EU. Do you remember? Debate of many politicians. Should we leave EU or we stay? Leave or stay? Boris Johnson, Nigel Farage, and all of them saying, let's take control back. And while other people talking like we need to stay with the EU, we are part of the family. So at that point in this chapter, all about EU and the UK constitutional framework, that's what we will discuss, not politics. Now, before Brexit, EU law had quite the royal status in the UK legal system, thanks to European Communities Act 1972, and that's what we passed it. So it was not inflicted, we adopted it. Could even, and at that point, it could have even overruled Act of Parliament, which made some constitutional pursuit clutch so at that point, it was tough to go against EU laws and all. So it could even overrule certain domestic rules at that point, and that was the major debate in the politics. So post-Brexit, however, Parliament has reclaimed full sovereignty, and EU law now has much more we got it, like we retained it, but domestic role, it is equal to other laws. So we will try to explore like what it means and how it worked. So we see the Brexit scenario. The European Communities Act 1972 meant that EU law could trump UK legislation. Imagine EU law as the boss at work and domestic law had to take orders where conflict occurs. UK courts were bound to follow this chain of command, creating an interesting dynamic between national and international law. So it was supreme, it had direct effect, and courts had to balance between domestic laws and EU laws. So there were different types of EU laws, like there were three main instruments. One was regulation, and second, directives and decisions. So regulation were the most direct, like they just landed in UK law like a pre-assembled IKEA chair. You got it? It lands. Ready to use. You don't need to do anything. Directives, although directive mean direct, no, it was not directive. Those that required the UK to achieve results, but left the assembly to domestic law, that you just go and do it on your own. And you need to fulfill the demands or requirement of directive. So decisions, meanwhile, were binding on specific addressees. Think of them like private memos from EU headquarters, and those were binding. You need to follow them. You needed to follow them, not you need to. Don't tell Nigel that I said you need to follow them. No. So let's talk about role of CJEU, that we call it, like Court of Justice of the European Union, the CJEU. For short, we call it. UK courts could refer questions on EU law to CJEU, which acted like a referee in a very complex football match. The decisions were binding, ensuring consistent interpretation across all member states. And UK courts then had to adjust domestic law interpretation to comply. So no one got a red card from Brussels, So be careful that Brussels is looking at you at that was looking at you at. So, to understand Brexit and retained EU law, this is one of the trick question in SQE. This timeline will make you understand everything. So, United Kingdom firmly exited the European Union on 31st of January 2020. That's what we need to understand. And their transition period started and it ended on 31st of December 2020. So need to understand that transition period starts from 31st January, but it ends on 31st of December. And in between, we got transition period. In that period, EU law continued to apply
as a transitionary arrangement and all. So once we reached 31st December 2020, afterward, all, all or most of EU law that we adopted became retained EU laws. And now those EU laws are same as our domestic laws. So to prevent legal uncertainty, the European Union Withdrawal Act 2018 created retained EU law. That was to preserve those laws which we were part of it. Like, instead of just passing all those laws and different subject matters that we were already abiding by, we retained them. So that's most important thing for all of us to understand, that 31st January 2020, still it is transition period for a year, and that ends on 31st December 2020, where EU law, retained EU law, becomes equal to our domestic laws.
So another thing, like post-Brexit legal position, so that's what is very important and it is tested. So EU law no longer dominates new UK legislation. Retained EU law only governs pre-Brexit matters. Court may look at pre-Brexit CJEU decisions for guidance, and those are not binding. So the Supreme Court and Court of Appeal have the discretion to depart from these decisions now. It's a bit like being allowed to ignore your old school rules once you have left. So at that point, so it's a bit freedom, but moving away from European family. So another thing is assimilation and reform. So that's what we need to understand, that 2023 uh, retained EU law, revocation and reform act that we got it. This act effectively normalizes retained EU law into domestic law, revoking certain provisions, removing the supremacy principle, and converting the rest into ordinary legislation. Essentially, it made retained EU law just another citizen of UK legal system, no special privileges, that those are equal to other laws. We adopt you, we adopt your laws. So interpretation and government powers at that point is very important. So court apply UK statutory interpretation, like principles that we got it. So pre-Brexit CJU decisions may be considered but are not binding. The government can preserve, update, and revoke retained EU law via secondary legislation, but major changes require parliamentary approval, like if it is major part. It's like having a garden where you can plant and prune, but Parliament holds the fence and the key to the shed at that point. For SQE tips and pitfalls, so remember, retained EU law matters only for pre-Brexit legislation. And post 31st December 2020, UK law is fully sovereign. Do not confuse direct effect with retained law or assume CJU case law always binds. No, it does not. But alert to the 2023 Reform Act. There are certain changes which can affect how retained EU law is applied. The good rule of thumb: know the timeline, know the status, and never assume EU law still wears the crown. Not at all. We got our crown back. So thank you very much for joining today. Have a good day or evening, whatever. Ta-da.